I want to turn next to striking out. Rule 37 deals with this, and a tribunal can at any time on its own initiative or after somebody's made an application strike out all or part of a claim or response. The grounds for striking out are as follows. 1. That it's scandalous or vexatious, or that it has no reasonable prospect of success. 2. That the manner in which the proceedings have been conducted by or on behalf of the claimant or respondent, as the case may be, has been scandalous, unreasonable, or vexatious. 3rd, you can get struck out for non-compliance with any of the rules or with an order of the employment tribunal. 4th, striking out can occur if the claim has not been actively pursued. 5th, if the tribunal considers that it's no longer possible to have a fair trial in respect of the claim or response or the part to be struck out, then striking out can occur. However, in all of these cases, there's got to be a reasonable opportunity to make representations, either in writing or if requested by the party who is on the receiving end of the strikeout, at a hearing. In the case of a response, if it's struck out, it's as if it had never been presented, and the consequences under Rule 21 apply. I want to turn now to two draconian powers that the tribunal has. The first is the unless order, and the second is the deposit order. Looking at the unless order, this is dealt with under Rule 38. If you're on the receiving end of an unless order, take it very seriously because it does what it says. So, an order can specify that if it's not complied with by the date specified in the order, then the claim or response, or part of it, shall be dismissed without further order. In other words, it's automatic. The tribunal gives written notice to the parties, but that's just to confirm dismissal. The dismissal itself occurs if the action which you were ordered to do is not done by the date specified. The tribunal will notify that you have 14 days within which to apply to set aside the dismissal of the claim or response. So you can apply, in other words, for a set aside within 14 days of the notice being sent. Now, there's only one ground. The tribunal has to be convinced that it's in the interests of justice to set the dismissal aside. Unless you ask for a hearing on that point, the tribunal determines it on the written representations. A dismissed response is once again treated as if never presented, and you can see the consequences under Rule 21. So an unless order is a very extreme order for the tribunal to make. It'll generally be made where there has been previous default on ordinary orders, so the tribunal has to get tough with the defaulting party. But it's not confined to that. There may be some situations in which it's just appropriate to make an unless order because of the importance of the issue that needs to be dealt with, or the time that the case is taking, for example. Turning next to deposit orders, these are dealt with under Rule 39, which clarifies how the tribunals used to treat these matters. First of all, there's got to be a preliminary hearing on whether a deposit order should be made. And the tribunal has to consider specific allegations or arguments. Now, I'm going to refer to those as a point, but they could be factual allegations, specific ones, or specific legal arguments, for example. In order to reach the conclusion that a deposit order should be made, the tribunal has to consider that the point has little prospect of success. And it has a power to order a deposit of up to £1,000 as a condition of pursuing that point, so the factual allegation or the legal argument. What this means is that different deposits of up to £1,000 can be required in relation to different points. The tribunal is obliged to make reasonable inquiries into the ability to pay the deposit, and they must have regard to that information that they derive from that inquiry when ordering the amount to be paid. The order for a deposit has consequences. The way it works is this. The notice of the order gives the reasons for the order. So with the order, you should get the reasons for it and also a notice of the potential consequences of the order. There are two consequences that you need to watch out for. If you fail to pay by the specified day, the point, so the allegation, the argument, is struck out. And if it's a response, it has this Rule 21 consequences. If you decide to go ahead having paid the deposit, and the tribunal hearing the case ultimately decides the point to which the deposit order relates, for substantially the same reasons as those set out in the deposit order, then first of all, the conduct in pursuing the point is deemed to be unreasonable for the purposes of whether or not a costs order should be made or a preparation time order should be made, unless you can show that to the contrary it wasn't unreasonable to pursue the point. The second consequence is this, that the deposit is paid to the other party or parties, and it can be set off against any costs or preparation time orders that might be made at that point. Otherwise, the deposit is going to be refunded